Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi everyone, welcome to episode 76 of the Immigration Lawyers Podcast. I've been not doing as many podcasts recently just because things have been so busy and just the daily life of an immigration attorney has been so time consuming. So a lot of different legal things popped up. As usual, there's more of a bias towards benefits-based immigration than removal, but there's so many different things that came up I wanted to talk about that I'm going to go through a lot of stuff that might not make sense when going in order, but they're just important notes to know if you're practicing immigration law that are really interesting. I've switched the primary website where I hold the videos and podcasts. It's on immigrationlawyerstoolbox.com, www.immigrationlawyerstoolbox.com. It's also available on iTunes and YouTube on the YouTube page, Immigration Lawyers channel, and on iTunes, Immigration Lawyers Podcast. But you can find them all in Immigration Lawyers Toolbox as well as like a Drudge Report type news thing for immigration events and agency news that pops up. So on the homepage, if you visit there, it'll be the most recent immigration news that affects practitioners there. So one of the biggest news that happened that's really not clear what it is yet is the public charge proposal. Before the administration released the terms of what they think will be the public charge rule, there was a lot of word that scared the hell out of a lot of people and created a lot of time on the phone for me. For people who are afraid that had green cards and were going to naturalize, or afraid of the effects of the public charge rule. But when it came out, the proposal is supposed to only affect those trying to get a green card, so inadmissibility. It was like 450 or 480 pages. I read through it. There's a lot of different things that are changing, unfortunately. We'll see what actually goes through. But it creates a lot of hassle, and a lot of people now are not getting benefits that they can get because they're afraid it might cause consequences, and a lot of people didn't get the news that it only affects inadmissibility issues for getting lawful permanent residency status, so when they have a green card, not getting benefits that they paid into or they deserve or they're entitled to. I think it was really a propaganda method that worked really well for them to get what they wanted without actually changing the law to get it. And so that was somewhat of a success on the part of the administration and their goals with regards to the public charge rule. Now I'm going to talk about the Department of State's liaison meeting with AILA, which was really interesting, but a couple of notes that came out of it with regards to the public charge rule is this, and practitioners have seen this recently in a lot of consular processing, especially at CDJ and Ciudad Juarez, where someone, if they have a joint sponsor would go to the interview, the applicant and beneficiary will go to the interview, show joint sponsorship documents, and they would deny the case, saying the joint sponsor wasn't a relative or a close friend or something like that, so they can't be a joint sponsor. The State Department, in their liaison meeting notes, said that no, that is not the rule as listed on Form I-64, the instructions in the actual statute, that there's no requirement that the joint sponsor, be related to the applicant and beneficiary. It could be anyone as long as they sufficiently provide documentation needed and make the income needed or have the assets for the affidavit support. So that was a really tough and ridiculous thing that the embassy was doing, and it just goes to show it's just so difficult dealing with this whole immigration system that has 50 different heads and each want to do what they want to do. Also, what happened was with people who got the denial or the refusal based on having a joint sponsor that wasn't related, if they had like an I-601A waiver already, the I-601A waiver would be canceled out and the embassy would require them to get a new one. Anecdotally, this is from the reports coming from the immigration lawyers. So the State Department also said that that's incorrect. Even if there was a refusal, they shouldn't have voided the waiver, so they can still use that waiver. And so that's like dramatic thing. People spend thousands of dollars to get that waiver, get it approved, the stress of that, go overseas, not overseas necessarily, but leave the country, leave the borders of the United States, and then have to deal with that. It's ridiculous. And this has been happening for a couple months now, so I'm sure some practitioners were forced to submit new waivers, so additional filing fees and attorney fees and time-consuming nature, and be stuck outside the country when they expected they'd be coming in rather quickly. And now the State Department's actually saying, oh no, the embassy was wrong. So it's a pretty crazy issue. The State Department also issued language again about the domicile requirement, reiterating that it's not a requirement that the petitioner be in the U.S. before the beneficiary applicant comes in. They can promise to come with them at the time that the beneficiary applicant is going to come in. So there's that leeway, but for some cases, some embassies are not down with it. They want to see the person, the petitioner, in the United States, have property and such. What I recommend is clients to have some sort of residence in the U.S., like maybe it's a lease agreement or something like that, or a job offer, if they're going to go as far as not entering the U.S. for domicile requirement before the beneficiary does, or in that case, coming with them. But this is a big issue. The domicile requirement it's just like a paragraph in the statute. And so it leaves us so open-ended for abuse of interpretation, and it becomes a really big problem. I see this with probably, I mean, it's only a few cases a year that I deal with this. Usually the petitioner is in the U.S., but a lot of times I just force them to bring the petitioner here because it's too risky having overseas. And frankly, it depends on the country that you're coming from. So, but particular issues I've had with domicile requirement are at the embassy in Turkey, Ankara, dealing with Iranian clients where the petitioner is not living in the U.S. or waiting for the beneficiary to get status to come with that. And that's where I've seen domicile issues in my cases. But I'm sure other countries have to deal with the same thing. Now, jumping to a completely different subject is quickly biometrics appointment notices. I had a couple of cases that they didn't get their biometrics appointment notices for adjustment, had to call it in and hassle them until it was finally sent. I have an I-751 removal of condition case, which is a basic removal of condition case. You know, the couple is together, it's legit, all that kind of stuff. It's been several months. I haven't got a biometrics notice. I called them up multiple times and they said that no, it's coming, they're just, you know, delayed because they're too busy or something like that. And I talked to another practitioner that does a lot of I-751s, and he said this year he's had like 5 cases that haven't gotten biometrics appointment notices yet for their I-751. So I think that's a trend. Along with not getting notices, the National Benefits Center said that there's some sort of glitch that prevented them from sending approval notices for adjustment cases to the attorney, and we're only sending it to the beneficiary and petitioner and the applicant. So as an attorney, I was not getting approval letters for the last 2 months for my cases after going to the interview and getting approved. So they said they're going to fix that up and resend the ones that weren't sent. So that'd be good to have that just for your records. But it's just daily problems popping up. Now, the liaison, the DOS liaison report, which I'll just talk about it quickly, is it occurred on October 18, 2018. It's on AO's website, but also if you go to the State Department's website, they released it there too, the Bureau of Consular Affairs, dated October 18, 2018. It's a must-read. I think it's a little long, but there's nuggets of gold in there that you probably should keep a copy with you, because you could always refer to it when the embassy or the consulate is giving you hassle. They say, listen, the State Department has issued language that says this is the appropriate way to deal with this any issue. With regards to travel ban, they said as of September 30th, 2018, only 1,836 waivers were approved, which is a drop in the bucket probably up to the total number of immigrant visas or just visa applicants coming in. What's weird is I learned about this one case for a colleague of ours who had a U.S. petitioner petition for his parents 2 years ago. They went to the embassy interview, he got stuck in administrative processing, then the travel ban kicked in and they're just waiting. Parents went to another embassy and requested a tourist visa and submitted waiver paperwork. And this whole idea of submitting a waiver, it's just all over the place. Depends on which embassy wants to accept it and which ones don't. But through the waiver process and begging and talking to the consulate and also getting congressional help, they approved a tourist visa for the parents to enter the United States, which is kind of weird because a tourist visa normally is denied anyways if you have an immigrant visa petition pending and you've had an interview and you're waiting to get the green card. Just to approve the waiver for the tourist visa but not the immigrant visa while a green card case is pending, none of it makes any sense. And it just goes to really how ridiculous the state of immigration law has become in our lifetime. So moving on from that, more stressful stuff is the memo for automatic denials instead of having RFEs. And this was a big thing that popped up, which is we're probably going to see the direct effects of it now, I guess, because it's been a month or two since it came into effect. But first of all, you know, the USCIS said that they're going to start not issuing RFEs if they feel like an important document is missing from the very beginning from the initial application package. Well, this creates problems because I've had tons of times when USCIS claimed I didn't send something when I did. They did put checklists on the form website, so if you go to uscis.gov and then go into like I-130 form, that would checklist of what they expect to be original documents. But a lot of problems still emerge. Like our passport photos are considered documents that you have to submit or don't have to submit with the initial application with the RFE on that. I've had times where we sent passport photos and they said they didn't get it. I mean, you know, passport photos are small; they could fall out of the package and then get lost. Also, what about marriage receipts? So in California, at least in Los Angeles County, Ventura County issues same-day marriage certificates, but in Los Angeles County, when you get married, they get a marriage receipt, and then many weeks later, you get a marriage certificate. For years, I didn't submit the I-130 marriage cases until we got the actual marriage certificate in the mail, but it was taking longer and longer to get it from, you know, California State Government of Sacramento. So I started just submitting it with the receipt, and it's been working for like 3 years now. I've just submitted the receipt with a letter in the application package, the combo package that says, and this is for adjustment, when the interview comes, we'll bring the original marriage certificate with us. Well, now with this new law, are they going to consider the marriage certificate not the original, not the proper document and deny it or not? So now I'm going to wait to get the actual marriage certificate in the mail, which is going to take weeks and probably 2 months longer before I can submit the application. So it caused additional delays. Now, I do have to say that I appreciate the annoyance of the USCIS officers have to go through, adjudicator has to go through when issuing an RFE, and then waiting for a response, because like before I submit a case, I kind of do the same thing with the client. So I send them a list of documents I need. A lot of times they send like half of it, and many times, enough times, I'll have to wait, you know, months and months to get 2 or 3 pieces of documents. And when they finally do send it, you know, it's been so much time since the previous time, and I do take notes of what's missing and stuff, so it's a easier read to recap what was happening with the file. But I still have to be like, oh, I got a new document, I got to see how this fits in there, and then reorganize it and reconnect with the file to get it. And that's kind of hard. So for RFEs, when the adjudicator does send that out, and they probably do with a large volume of these kind of cases, when they have to wait weeks, you know, months to get something, and then they have to look back in the file to see what's going on, what's missing, what's not. It is frustrating, but regardless of how frustrating it could be, how time-consuming and lack of efficiency that it has, the consequences of just straight-up denying case are really too strong, especially if the consequence of further of that, according to the new memos, is that the person could immediately sent to could be NTA'd for removal proceedings, not really given an opportunity to, you know, resubmit or something like that. So it's a, you know, one false move is like a domino that leads to all sorts of harsh consequences, and sometimes they can be fixed, but that's with potentially years of legal work and thousands and thousands of dollars from the applicant just to fix one innocent mistake. Now, going back to the Department of State's liaison meeting with AILA, they did make note about prudential revocation. So I get phone calls on this a lot. So you have like an Indian H-1B case. The gentleman, usually the gentleman, is here and then gets a DUI, and then they get notification from the State Department that their visa is going to be gone and because of the DUI. These are called prudential revocations. And what's happening is USCIS also, in some cases apparently, has denied status for these people once they get their visa revoked. And the State Department made it clear, this is a prudential revocation, so when they're here, they have status. It's just that they leave, that visa is not going to work until they go back to the embassy and get a new one, and they have to deal with the issues of the public health issue of being potentially an alcoholic and doing all that stuff to fix it. But they still have status, and apparently in some cases USCIS has been revoking the case, the status and State Department said they're going to work with USCIS to try to fix this issue. It's a prudential revocation, not automatic revocation while they're in the States that's going to revoke their status. So that's something important to know if it happens to one of your cases. And there was another news report that came out, and this is incredible. Apparently, U.S. is denying passports, and apparently they started this at Obama's time, but it continues now, to American citizens that were born along the border, especially those who were born like 50 or 60 years ago and had a midwife that was a witness, and through that witness of the midwife having a child born at home, on the Texas side, for example, of the U.S.-Mexican border, they received a U.S. passport. And apparently one border officer actually got hit with this. He traveled and then he came back. They revoked his passport and they requested proof that he was born in the United States, showing rent records, lease records, or other records of his parents living in the U.S. at the time, and getting documents for a person that's in their 50s or 60s from 50 or 60 years ago from their parents who probably passed away is going to be near impossible. So it's just kind of crazy how this stuff works out. It's unbelievable. Another thing with regards to State Department and U.S. treaties, I had an interesting call from a Native American who was in Canada and wanted to come to the U.S. Because he's part of a tribe in the Northeast. And there's a thing called the Jay Treaty, for instance, J-A-Y. What's interesting about it is apparently the Native American lands cross borders, and the U.S. has a treaty that automatically grants U.S. citizenship to people that are members of this tribe and could prove it, and they're automatically U.S. citizens. And you want to know how to get that? USCIS website, or I think State Department, had a link that explained it. So I told him just go to his website, and if you needed more help, then we'll have consultation. But it's really neat. I didn't know it existed, but there's all sorts of little things that exist in immigration law that are always interesting to see. Now, more State Department related stuff, I guess. One good, one bad. The E2 treaty for treaty investors. The U.S. had a treaty with Iran for, I don't know, since like 1950 or something like that. And even after the Iranian Revolution, still permitted Iranians to invest and start businesses in the United States in the E2 treaty, which was wonderful. It's a good way to bring the countries together and cross cultures and all that kind of stuff. Well, the State Department, with its head, Mr. Pompeo, an interesting gentleman to say the least, he pulled out of the treaty with Iran. This is a treaty of amity with Iran that was signed by the Shah and all this kind of stuff way back when. And essentially, and the State Department hasn't explicitly said this or spoke about this more than just than Pompeo's press conference said he's ending the treaty. But when you look in the treaty, it says once someone announces they're going to leave the treaty, it's still valid for a year, and after that it comes revoked. So what's going to happen with people that Iranian that have E2 treaties, I guess they could renew the case, and I can't say this for sure, but I think what happens is, because there's cases, I think in Bolivia or something like that, it was a South American country or Central American country, a South American country, that had this go through as well. They could renew it. No new e-visas could be requested, but they could renew them until the expiration, and then after that it's not renewable. So it creates a lot of havoc. People who are on the E2 visa have businesses and are operating, all of a sudden have to get out. So that's going to be a mess. On the other end, a little bit better, New Zealand signed the Kiwi Act with the United States. President Trump signed the act, which allows the E2 and E1 treaty programs to essentially begin with New Zealand. But the problem is, and the State Department liaison report said, is New Zealand doesn't have the reciprocal program for them, for an American citizen to go to New Zealand and do an E2 treaty kind of thing. And until New Zealand sets that up, they can't do it in the U.S. So hopefully get that up and running, because there's a lot of people in New Zealand that would be interested in starting business in the U.S. and they're already English speakers, and so they're a good fit to be able to quickly come here and launch businesses and help the economy here and bring our two countries together. So that was an interesting thing. Now, on the part which kind of goes to removal and all that, President Trump did announce executive order that they won't be accepting asylum cases from, I think, last week forward for people that entered without inspection, but withholding and Convention Against Torture, CAT, are still going to be okay. He's also talked about challenging birthright citizenship. It's very controversial, and he sent troops to the border. Who knows? I mean, they say it's for the caravan, but I don't think you need troops for that. I think Border Patrol could handle that, frankly. Now, ICE deportations are at record high since up to like 1992 or something, and the backlog for immigration court cases reached 1 million. So in one sense, again, they're trying to deport people as fast as possible, but the system can't handle it even with the new judges. So we'll see what happens. There's still going to be a backlog. The I-485 NTA policy for when someone gets denied NTAs, 485 or change of status is moving forward. Their focus is going to be on humanitarian cases right now that they get denied. They'll get NTAs. Like employment-based cases aren't included yet, but that'll come soon enough. Also, the Ninth Circuit said that the injunction against stopping deferred action of child arrivals is going to continue. Trump tried to get the Supreme Court to make a ruling on it, but nothing yet. So essentially, you can do DACA renewals, but no new DACAs, and advanced parole is not going to be issued. So that's good. I mean, if you have a DACA case and you know if DACA is going to expire even a year from now, just file it to see what happens. It's worth it to get that renewed so they get extension on the work visas and everything as soon as possible. What's going to be probably a very annoying thing is they're deciding to change the InfoPass system, and the pilot program is going to be in Los Angeles, the District 23. Where they're not going to be issuing InfoPass appointments anymore. Apparently, you have to call it in, and then you can do emergency ones sometimes. It's not exactly clear how it's going to play out, but it's probably going to be a mess. I mean, InfoPass itself was a mess, but it's just going to get worse. Now, going back to border security, there was a report that more than 500 employees of the primary border security agency were charged with drug trafficking, accepting bribes, and a range of other crimes over a 2-year period. That's just crazy. And I talked about the importance of CBP and border protection many episodes ago. It's such a sensitive area, and it's ripe for corruption because of the amount of power and lack of oversight happens because you're at the border and you're dealing with individuals on a case-to-case basis. And not to tarnish the whole agency, CBP's work is really difficult. But it's one of those things that you have to be very careful of because it's just so easy to go into corruption when you're at the border checker point. Because of the amount of power that person has, and again, lack of oversight. So, as you see, when you have 500 employees charged with drug trafficking, accepting bribes, and a range of other crimes, it just goes to show that that's the reality of happens, and it's probably a higher number than that. I just know so many good CBP officers, both at the border and at the ports, and it sucks because, you know, once one of these, even one has some bad thing that they do and get convicted for, all of them are going to be shined that bad light. It's unfortunate. So it's really something that has to be self-policing to keep the reputation good, but it's hard. You know, it's essentially CBP is a police agency, and you always know the code, you know, don't rat someone out, something like that. But it's not ratting out when they're ruining the prestige and the trust in the agency. So it's a shame that that's the case. Hopefully they could police themselves better, and there'll be better oversight, especially by the House Judiciary Committee, which is supposed to be doing this. But on various aspects of Judiciary Committee meetings, they're failing when it comes to immigration. On a side note, be careful what you say on these listservs. You know, there's a lot of immigration listservs. I started one originally that a lot of people listening to this probably a member of. But now with the increase of them online, you know, both you know, AILA listservs and non-AILA listservs and Facebook listservs, you know, EOIR staff could be on there. ICE staff could be lawyers that are on there as well. It's hard to police the whole thing. There was a FOIA request made by one attorney, which found out that EOIR employees were emailing copies of information shared on listservs to share with each other, either strategies or information about attorneys and stuff. So it's a really tricky thing. Be careful what you post. Don't have a sense of security or privacy, or thinking that these things are policed well enough to avoid that from happening. To protect your client's interests, definitely, and your own interests. Definitely be mindful what you say there, because it could come back to be a problem. You know, moving on, Bank of America is freezing accounts of people, for example, if they have Iranian passports or if they can't show proof of U.S. residency. So, you know, Bank of America is becoming an immigration agency onto its own. It's very a sad shame that they're just making up things. Right now, I was refinancing something. They asked, "Are you a U.S. citizen? And what other passports do you have?" And it's like, what the hell does this have to do with you? But I guess the banks are very afraid of getting fined too, so they're doing this stuff. But it's not appropriate for them to be getting to this stuff. So, you know, shame on Bank of America for doing that. And this news is next one's coming from a little while back. USCIS had changed their website when it came to the STEM OPT rule, where a person could work at a third-party work site, and then their website they just made it wrong. You can't do that. Luckily, hat tip to Attorney Wazen. He's a semi-immigration attorney, more of a litigator, federal litigator. He sued them on this, and once they got sued, they pulled back, which just goes to show you got to sue the hell out of them to keep them on their toes and keep them doing the appropriate thing, because just being nice and talking to them is not getting anywhere. They really have to get the force of law, the courts, to be able to keep control of the immigration system, have them not just make up things willy-nilly. And also, USCIS issued a memo that they're now going to ask the consultation agencies for O visas, the labor unions, to directly send the consultation letters to them instead of having attorneys send copies. Apparently, allegedly, I guess some attorneys may have made up their own letters or fixed them or changed them, and that's their way of avoiding that. So that's that. Now, one memo that was issued that's really important for applications for adjustment of status that unfortunately took me a while to really understand what the hell they were talking about is for the medical, the Form I-693, the new rule is that when you file for adjustment of status, the Form I-693 medical checkup has to be less than 2 months old. And my initial interpretation of that was that you have to get the medical 60 days before filing, and you have to submit it at filing. But upon further review and looking into the adjudicator's field manual, the whole point is that the medical has to be within 60 days of the filing of the application, but if you don't submit it with the application, you could bring it to the interview too. It just can't be older than 60 days from the time that the application is submitted. So that's that. But the way they worded it in the initial policy memo overview was very badly written, so you have to go into the adjudicator's field manual to see the whole thing, how the explanation was happening. Actually, there's not much more left. I thought it was going to be like a 2-hour episode because all these things piled up. But the Center for Immigration Studies, which is one of these anti-immigration groups, issued a review. Obviously, they're being negative about it, but they're saying that the states with the largest increases in the number of immigrants since 2010 were Florida, up 721,000, Texas, up 712,000, California, up 502,000, New York, up 242,000, New Jersey, 210, and so on. Washington, Massachusetts, Pennsylvania, Virginia, Maryland, Georgia, Michigan, North Carolina, Minnesota, in that order of the increase in immigrants. But you take it to a positive. If you're going to be an immigration attorney, these are the markets that have the most immigrants and most clients. So Florida, Texas, California. I get a lot of phone calls from people in Florida, even adjustment cases. But since I can't be there at the interview, and usually Florida cases always have weird issues, just Florida is a peculiar state. I don't take on those cases usually. And I get calls from Texas too. In California, I'll take cases all across California, unless there's somewhere where it's too complicated to travel to. Fresno is a hassle to travel to. It's like I don't take Fresno cases, but I'll take San Jose and San Francisco cases. But it's if you go to the website and see this, it'll help you if you're deciding on you're a law student or you're just starting to practice immigration and you're thinking on where to go. Well, these are markets that are just growing. So thank you, Center for Immigration Studies, for helping us know what the good markets are to get there. There was another report. They're saying 67 million people living in the U.S. do not speak English at home. I think it's intent to shock people. I don't speak English at home, but as you can tell, my English is pretty good, and I might make a living off my language. So, English spoken at home for most of American history was not the norm. I mean, German immigrants wouldn't speak English at home. Italians wouldn't. So it's a scare tactic. Now, to say like, oh, they don't speak English at home. What matters is English is the language of business and outside the home. As long as they speak that well, it's good. Now, I do have clients sometimes, especially when I used to do DACA cases, where the children would come and they could barely speak English and they had such thick accents, even though they came here when they were 2 years old. And frankly, the parents would come. Their parents who were immigrants and came as adults spoke better English than the children. And I see this not just in the Hispanic community. I see this in even the Iranian community and people like from Beverly Hills where they were even born here. That's shocking to me when you can't speak English well when you've been here since 2. That's a problem. And it's not what the immigration haters are talking about. I'm saying in the functionality of society, to grow up in a community and not be able to speak the language well, it's kind of ridiculous, and it really hurts yourself and the community because the communication is so important. But the stat is staggering, 67 million, but the country's much bigger and grows, so these numbers are going to grow with it. Interestingly, Louisiana passed a rule, and this is probably going to challenge quickly, that said they're going to ask for immigration status when someone gets married. So if you have clients out of status in Louisiana planning to get married, don't send them to the courthouse because the judges will call ICE. That's a scary thing to deal with. I had some different news in Los Angeles, and everyone knows about notarial fraud and all that kind of stuff. There was an official report, an arrest of a Persian language TV host who was acting like a lawyer essentially, notario slash telling Iranian applicants that she's a lawyer, and it was crazy. She was bribing USCIS officers to accept the I-693 for the medical report and bribing him to accept other stuff, lack of continuous presence dates for naturalization applications, all that kind of stuff. And she was successful in many years, and at least they have 30 cases they could show that. And they put her name out, and she's got jail time for it, which I'm glad, because she worked in my market in Los Angeles, and I'd have clients coming and saying, well, my friend got approved, my friend did this, and they were fine, and they were like kind of saying, you don't know what you're talking about to me. I was like, it's not possible, like the naturalization case shouldn't get approved. But now when I see this, I know, oh yeah, that's why it was approved, because it was fraud and bribery. But what I didn't like about the Justice Department's report is it didn't say the names of the USCIS officers who approved it. I think they should get much larger prison sentences. Frankly, if a government officer is accused of corruption, whether it's CBP, Border Patrol, or CIS, they should get 5 times whatever a regular person would get, a civilian would get. They should get worse, because they're in a position of trust. And that's the last thing they should do, is be accepting bribes and stuff like that. There's rules here, and it shouldn't be up to me as an immigration attorney to be wanting to enforce the rules. They should be doing it themselves rather than getting bribed. And they get bribed by $1,000. They give up their career for a $1,000 bribe. And the worst case was, I think it was in San Diego, where the officer said, there's a Filipino client that said, bring me like 1,000 of some sort of Filipino cookies, and that'd be the bribe for getting approval. And it was for a party that USCIS was holding. It's like, bring these bribe cookies out to the USCIS party, and they were able to arrest that officer. But it's kind of crazy, just how everything is crazy. And if you were following the news, and obviously you probably heard the fires and the shooting in Los Angeles and Thousand Oaks, and where I grew up. It's just, everything is kind of crazy right now. Probably the 60s during the Vietnam War and the civil rights clashes, that's probably the craziest the World War II was crazy, World War I was crazy, Great Depression was crazy. As stressful as I think it is now, it's actually, looking at that, it's not as bad regardless of all the death and chaos and destruction that's happening. I guess World War II and civil rights and Jim Crow, those are pretty as bad as you can get. But going back to immigration law, EB-5 is at the lowest in 5 years. That goes without saying, with the amount of hassles CIS gives it, with the issues with source of funds, the program just being slow, insecure of whether it's going to get renewed or not. It's just a mess. Unfortunately, there is a place for an investment-based immigration program that leads to lawful permanent residency, but more and more it looks like whatever we have right now isn't it, and I don't really know how that's going to be fixed. So that ends the stuff where talking about immigration laws and stuff, but I just talk about random stuff. I was watching the Joe Rogan podcast, and they had the old trainer for Mike Tyson, and they had a falling out. He was no longer a trainer, but he was making the claim that Mike Tyson is not the greatest or wasn't that great. Mike Tyson, if you watch, he would knock people out. It was pretty interesting. If you're into boxing, it was a great boxer. But his point was that Mike Tyson always just went in and knocked people out in the first round. What makes someone great and really know what they're doing is if they had to face adversity and they overcame it. So if they were to round 12 and they're fighting, but eventually they overcome it and beat it down, kind of Muhammad Ali stuff, facing really difficult stuff in life and overcoming it, that's a true champion or a real top person in their field. So I was thinking, and then he started saying, like, look at lawyers, like, it's really easy to do a basic, like, for me, the complicated stuff is a basic L1, which is like, IBM sending, like, sorry, motorcycle, like IBM sending like their vice president of operations from China to the U.S. That's going to be more simpler L1 to do. But we need to fight for the L1 when it's a new office and not enough employees, and then it's not clear how much money they're going to make and all this kind of stuff. And you get an RFE and then it's denied, and you go AAO appeal and you do lawsuits and eventually win it. Although it drains the hell out of the company. Going through that adversity is what in overcoming it, or having a denied L1 and then refiling it and then getting approved. That's the making of a great attorney. I have to put a niche for myself, because I don't, like, for marriage cases, I don't take marriage cases where they need waivers or if they need that criminal history. It's more concierge service to help people go through this stressful period that they're nervous about. The tough stuff I do is L1, but many of you do, removal proceedings or deal with 601 waivers or people with criminal history, and you really have to go to those interviews, and sometimes you go to HCIS interviews and you have to fight them, or you go to court and you have to fight ICE and the judge, teaming up against you, and when you win it, that's what makes a really good attorney. They can say, yeah, you're one of the, like a champion. So that's just something to think about, to really push yourself to try to be great You have to take on the hard cases and win them, and fight with them until you get it. And that's why I don't want to get into doing lawsuits, and I'm federal lawsuits, mandamus or whatever. But it's so necessary because they're just so ridiculous with some of these RFEs and denials that are coming in, that the only thing will teach them a lesson is getting sued and having a public record of how ridiculous some of these decisions are. But there's just a whole different practice field I have to get into. I'd love to have someone reliable that I could go to on the team that I could send these to. But that's just one of those things. Another thing is I was watching Shark Tank. I'm sure you know the show on ABC where they have entrepreneurs, would-be entrepreneurs come talk to some billionaires and millionaires to invest in the company, take them there. One thing that the Mr. Wonderful, something Leary, talks about all the time is he always says, "What's your client acquisition cost? What's your client acquisition cost?" And I always thought like, well, I'm not a startup, or as the business is, yeah, they should know their client acquisition costs. And I thought, well, I should know it too. I'm a business too. So I went back and I looked at all the costs I do for marketing, whether it's like online marketing or all this kind of different stuff, and also how much time I spend going to different networking meetings and what is it called, networking groups, and then lunches afterwards, all that stuff, how much I spent on lunch, how many hours I spent at the meeting and hours at the lunch, and then assign my hourly fee to that. And all of a sudden I saw like there was a lot of money being spent, and I see, well, where does business come in? Like all the time I'm spending on certain things, is business coming from that? Is the client acquisition cost worth it? Because through that, adding up all the money and time I spend and making that into a number, and then seeing how much income I had for this period of time and dividing it and all that kind of stuff, doing the math, I saw what my client acquisition costs are, and I realized I have to lower it, because even when I get a case and I charge my hourly, I have to include that client acquisition cost as an addition to that hourly, so I could see what a case really costs me. I shouldn't just be happy a case and I got paid, because there are a lot of additional expenses and time I spent to get that case. And so what I did now is I cut down drastically on a lot of my online marketing, a lot of my old networking methods, and to do the basics and use the time for that. And that's why you're going to see a lot more podcasts and stuff. I think this is a really good system I have, and a lot of it is just working with other attorneys and consulting too. That's a good business avenue that I have, especially because of the podcast. But definitely look into what your client acquisition costs are, do the math, and see what marketing works and what doesn't, so you don't waste your time on things that aren't going to lead to anything. And sometimes certain marketing things are feel good, you think you're doing something from them, but you're not, and it's really important to cut those out as soon as possible. Finally, there's been discussions on Twitter. There's lawyers talking about, I think Michael Whalen or something, it's not an immigration attorney, it talks about the importance of rural representation, rural attorneys. And it comes up a lot in immigration, because there's a lot of immigrants that need help in rural areas, but they don't have like 1,000 law firms like Los Angeles or New York does. And what happens is they have to travel long distances to talk to a lawyer, or they have a general practitioner that does civil kind of stuff, or maybe some criminal. They have to dabble in immigration, and so now how do we help that situation so even rural people get representation and due process? I think you could go work in a rural area. That might be one option. But one thing, what's the goal of this podcast and my creation of the Immigration Lawyers Toolbox, and if you've seen episode 75, that was before this, and I'm going to really focus on this more, is taking the educational aspect and providing more education. So if someone's in a rural-based practice and they have to dabble in immigration, they have good resources that are direct and easy to digest with regards to what they're supposed to be doing with immigration. So that was the intent of this podcast from the very beginning, one of the main reasons for education, but I'm going to be focusing and narrowing that in to do really focused educational tools through the Immigration Lawyers Toolbox for these rural practitioners and others, new members, new immigration attorneys, law students, people from other practice areas that are starting to switch, so you get the real hang of it. Because one thing it is although there's a lot of immigration attorneys, we still have more people that need representation. And one thing is, I think the cost of it scares off a lot of people. But if you have more attorneys that are available at more different price ranges, there'll be clients that'll come when that exists. And once general clients know that the fees are something that's doable, it's not a crazy amount, there'll be more of a market, because there's just so many people that file pro se, make a bunch of mistakes, don't have representation they need, and frankly they get an interview notice that doesn't get to them, and they miss the interview, and all of a sudden you get an NTA for not showing up to just an interview and getting denied and put into deportation just because they didn't have a lawyer who got a G28 who get a copy of things. Something even basic like that is worth having a lawyer. So whatever you can do to make different price scales that work for different clients that suits them is good, and education is always good. Somewhere they can go to where they can get the best information possible to the extent that I can, with the resources that I can provide, and sources, citations, and mentoring and everything like that. So the practice of immigration could be done right. Even if you want to do it, as hard as it is to do it right, because it's just so difficult. In the previous podcast, I was analyzing a Ninth Circuit case of Ma versus Sessions, and I'm so glad we don't have to hear that name anymore in these lawsuits. But the court spends about 30% of the decision just saying how difficult immigration law is, and how even USCIS makes their own mistakes and don't know what they're doing. So it's just such a tough area of law to learn. And it's funny, like I've been practicing, I don't know, for 8 or 9 years. Every day I learn something new, and I talk to people who've been doing it for 20, 30 years, and they say the same thing. Every day I learn something new. Add to that the fact that administration changes something every single day too, where it becomes really hard. So having resources that are on top of it, and locations they can go to is really key. And I hope the Immigration Lawyers podcast is one of these resources, and the Immigration Lawyers Toolbox as well serves as a headquarters. So if you like, please visit to catch up on the news and on future additional education resources I provide. For example, I added a page where it breaks down almost every single immigration term and definition it has on there as a quick way to see what something means. It's on the Immigration Lawyers Toolbox. Thank you so much for listening to episode 76. If you're listening on iTunes, please feel free to leave a nice 5-star review. If you're listening on YouTube, like it, comment. You can always email me directly at info@jqqlaw.com. I answer my emails myself. I guess that's it for today. Until next time, have a good one. Bye-bye.